Hello, good afternoon, and welcome to The Law. This is your Legal Light. It is your health law. And here on The Law, we make sure you get platinum legal education. Welcome. I'm Samson Ladi Anyanini. And this afternoon, Parliament has not been able to sit for a while now, and it does not look like it will be able to sit. Is it the fault of the Supreme Court? Is Parliament disobeying the orders of the Supreme Court? What are the consequences of disobeying the orders of the Supreme Court? We'll be right back. You're welcome back. My guest right here in the studio is Opoku, and certainly you know him just too well on the show. And he is going to help us with this discussion. Another colleague will also join us. And as you know, the Speaker of Parliament, Alban Kisford Sumana Babing, has, on the basis of a statement made by the Minority Leader in Parliament, Kesel Atoforsin, made an announcement that resulted in 4 seats being rendered vacant. After the Speaker did that, a number of things have happened. These 4 seats belong to Kojo Asante Suhum for the NPP, Cynthia Morrison, Agona West on NPP again, Amakwe Siama Fomina, who is independent and going for the NPP. You used to be with the NPP and then they kicked him out. He went independent and won and came in, and now he's going back as an NPP parliamentary candidate. There was also Kwache Aka, who is the MP for Memphis Central for the NDC. Their seats have been declared vacant pursuant to Article 97, Clause 1 of the 1992 Constitution. And the Constitution simply says that if you, having been into Parliament on the ticket of a particular political party, decide to now join another party or to go as an independent, you will lose your seat. And that's what is happening. And as you know, this was done on the 17th of October. And by the 18th of October, that's the very next day, the Supreme Court, upon an application by Afenyo Marking, the Majority Leader, stayed execution of that decision, suspended that decision. Then October 22nd, the Speaker adjourned the House indefinitely, and the Supreme Court subsequently heard the Speaker's application to set aside or vacate the ruling of the Supreme Court. The Supreme Court rejected that application. The majority then requisitioned a sitting of Parliament again, a recall of Parliament, they call it, and that happened on Thursday. The Speaker adjourned the House again. We'll get to know all the reasons, and most of you may know the reasons by now. Is the Speaker disobeying the Supreme Court's decision? Is the NDC minority disobeying the Supreme Court decision by refusing to leave the majority seat to go to the minority seat? These are the issues that take our attention this afternoon. Thanks for joining us.
Thank you again, Samson.
Great. So let's begin from this point before we get into the pure law. How do we get Parliament to sit?
Well, that's a difficult question. I might stray into some aspects of law as I try to answer this question.
Right.
Well, I said it's difficult because it appears that there are entrenched positions on both sides, the NDC, the NPP. But I think if I remember right, Parliament as at now is on recess.
No.
They're supposed to be sitting.
So they were supposed to resume, and their actual resumption was on the 15th of October.
Yes.
A day before the 15th of October,
So-
when they resume from the recess.
So Parliament is supposed to be sitting now.
Yes, it's supposed to be sitting. A day before
Okay.
the resumption
Okay,
from the recess, Afenyo Makin filed his suit in the Supreme Court.
Okay.
Because Haruna Idrisu, over the weekend, before that sitting,
Yes.
had announced in Tamale
That
at a rally
the four
that
MPs who...
the 4 MPs must lose their seats.
Yes,
Because
okay.
they have sinned against Article 97, Clause 1.
Okay. I think the Speaker simply has to call Parliament back. If he doesn't, and the NPP or NDC triggers the action they did to get him to recall Parliament, it will be in order.
That would be the MPP.
The NPP. The NDC can also trigger the recall of Parliament. I mean, both sides, either side might want to do that. When they come back, I know the question of where they sit will be an issue again. Where they sit, to me, and from the reading I've done so far, is not determined by law. I haven't seen that in the Constitution. I haven't seen that in their standing orders.
I understand that it is in their standing order.
The new standing orders.
That's what I'm told.
If it is,
according to the majority leader.
if it is, then the NDC is clearly wrong, disobeying the Supreme Court decision. Because Supreme Court, let's remind ourselves, the Supreme Court has not reinstated the 4. The Supreme Court only says that, Speaker Bagbin, suspend your decision. Let's have a look because there's a complaint before us. After we have looked at it, the Supreme Court may well say that, Speaker Bagbin, you are right. Those 4 must lose their seats. Supreme Court may say that, Speaker Bagbin, you are wrong. You have no right or power to declare those seats vacant. We will take that decision. Or that it should go to the High Court. And the High Court, in my opinion, if it should go there, is likely to remit that interpretation question back to the Supreme Court.
Because
Because they are
Constitution is not
rival.
clear.
Yes.
The Constitution is not clear.
It's not clear.
Why is it not clear?
Let me explain to you
Plain
why.
on its on the face.
If you read Article 97 as it stands,
Right.
it is clear how a member of Parliament comes to lose their seat. Let me go to the article. When Parliament is dissolved, you lose your seat. Automatic. When you are, as an MP, you are elected Speaker, you lose your seat. If you are absent without permission and you face the Privileges Committee, you lose your seat and you don't have a reasonable explanation. If you are expelled for being in contempt of Parliament, you lose your seat. If you resign, you lose your seat. You see, if you resign, there's no controversy. If
Parliament
you leave,
is dissolved, you lose
you
your
lose your
seat.
seat.
Yeah.
No controversy. Now, if you leave the party, you lose your seat.
That's
no
right.
controversy. But what amounts to you leaving your party? That is where the controversy is. In this instance, the interpretation put on by some people is that once you're a member of a party and you have filed to go independent, you have left the party. Is that the position of the law? That will require interpretation. Sometimes
the question you brought that led us to this is whether or not that provision in the 1992 Constitution is not clear.
yes.
What is not clear about it? It says, 97 Clause 1, a member of Parliament shall.
Yes.
Shall means what?
Mandatory.
You have no option.
Yes.
You have no choice in the matter.
I agree.
Shall vacate his seat in Parliament if, that is G,
Yes.
if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member.
Let's deal with this, please. You are a member of the NDC in Parliament on the ticket of the NDC.
Correct.
You leave the NDC to join another party, PPP, MPP, while still remaining a parliamentarian. You have left your party to join another party. There's no controversy.
Yes, so what is not clear about this?
If I say I am contesting the next election on the ticket of another party, but for this current parliament, I will remain on the ticket of the party which brought me to parliament, there's a problem with that. Has the MP resigned? Has he been fired? those questions will have to be answered. Whether or not he has resigned, he has been fired, or the mere filing of his papers to contest the next election on the ticket of another party amounts to him having left the party which brought him or her to parliament. That's where the controversy is. And that is the situation we have now.
My question is,
yes,
when you read what the Constitution says,
yes,
a member of parliament shall vacate his seat.
Yes.
You shall leave your seat.
When?
You don't actually need anybody to tell you that.
On what condition?
On condition that you have left your party, which brought you to parliament, okay, to join another party.
Yes.
Or you want to be an independent member.
Yes.
Then H, if he was elected a member of parliament as an independent candidate and joins a political party.
Yes.
This is for the Esiama.
Yes.
Because he went in as an independent
and
now
filed
he's contesting
as an MPP
candidate. Yeah.
Something that is exactly where the controversy is.
Why is this not clear?
It is not clear.
Why do you need the court to tell you whether this is clear or not?
Let's deal with Honorable Esiama's case. Mm-hmm. He came to parliament as an independent member of parliament.
That's correct.
He seeks to come back on the ticket of the NPP. That is different.
Can he contest as a member of parliament on the ticket of the NPP without being a member of the NPP?
I don't think the party will allow that.
Correct. The party's constitution, in their Article 6, says that if you endorse, it doesn't even say if you contest, if you endorse a candidate, where the party has a candidate, you have automatically done what? Forfeited your membership of the NPP.
That is the party's constitution. Has that been kicked in?
It says you have automatically forfeited your membership of the party.
Your employer says if you are caught stealing, you are fired immediately. You are caught stealing. Your employer continues using your services. Have you been fired immediately?
This one, it doesn't say that. This one doesn't say you'll be fired immediately. It says
let me change my
forfeiture.
Let me change my word.
It said you have automatically forfeited your membership.
Yes. Have the administrative processes of the party been kicked in to indicate that he has forfeited? Has the party informed parliament that
do you need administrative processes when they put in their constitution that you have automatically forfeited?
Samson, I believe that no matter what they write in their constitution, at the very least a letter should be written to you.
Why do they put automatic there?
Well, they put automatic there, that is their choice of word. And what I understand means that you don't have to go through any disciplinary process.
Okay.
Once you file or you endorse somebody, you don't have to go through a disciplinary process. Once you establish, first of all, even those facts must be established that you have filed, you have endorsed somebody.
That is not in contest now.
Yes.
Because there is the poll or whatever they call it, which shows that all these MPs in parliament have either moved from the NDC to go as independent, or from independent to MPP, or from MPP to independent.
Samson, let's stick to the Siama example illustration we were using.
Right.
You asked whether or not, because the provision in the NPP constitution says automatic, it means without more, he's out of the party. And that is where my position comes in, my contention comes in, that at the very least, you should be written to. There should be an indication from the party that we have triggered this provision in our constitution. So you are no longer a member of the party.
So until and unless the party writes, you are saying, even though their constitution says you have left automatically, you are still a member?
Yes. If they choose not to enforce it, a member of the party can enforce that provision by going to court, for instance, to say that because of clause this or article that of our constitution, Honorable Esiama automatically ceased to be a member of our party from XYZ date.
Did you follow when Alan Chamatin left the party?
The recent one, or the
Alan Chamatin, when he left to form his new group?
Well, I'm not sure.
So immediately he left.
Yes.
He went with so many of some numbers in the NPP, some leaders.
Yes.
Abubakar, what is his name? Sadiq, is it? And other people. what is his name, Boabinga Samoa, and the rest of them. The party wrote to the world to indicate that by their leaving, joining Alan Chermate, they have automatically forfeited their membership.
Samson, what did you say? The party wrote. The party kicked in that provision. In the case of these two MPs who are contesting as independents, has the party kicked in that provision?
Okay, so let me come to Osman Alassane. Osman, constitutional theorist Dr. Mame Mensah-Bonsu says once the constitution is clear, as far as the MPP constitution is clear, and it says you have automatically forfeited your membership, you don't need to be written to, nobody has to do anything. You have automatically forfeited your membership. In the same way that Article 97.1, why am I always saying 70? 97.1 says, for example, that upon dissolution of Parliament, you have vacated your seat. Nobody has to tell you that you have vacated. Nobody has to write to tell you have vacated because there's a dissolution. It says if you are absent without permission of the Speaker for a number of days, you have vacated. It says if you're expelled, if you resign, and so on. Do you believe that that is the right position of these provisions as well as the MPP's constitution?
I think I agree with her totally. Because you see, when words are used in the law, they are not used in vain. And when of all words, a particular word is chosen, it is the effect of that word that need be given in that law. And that's why the maker has chosen that word. Now, the automation, the sense of automation is telling us that nothing procedural need be done before you are considered not a member. I mean, I'm talking about the MPP constitutional provision.
And he introduced it and we veered there, but we will stick to 97.1. So you finish your point there.
Okay. So if the constitutional provision says you automatically forfeit, it means that there is no any procedural or administrative act that is required to make you a non-member of the party. And so if someone is duty-bound to apply a national constitution and he requires to know whether a condition stated in a constitutional provision is satisfied for him to trigger it off, and it is linked to the MPP constitution, he is bound to use it. And he is bound to give it the meaning that the MPP, the provision intends for it. And let me say this. Sometimes when you make a law, it leaves your hands and it leaves your jurisdiction. The fact that you have made the law does not mean that the interpretation of the law remains with you and you do whatever you like with it. No, otherwise we won't have court.
Well, people like Professor Kweku Asare,
yes,
disagree with this kind of position.
Okay.
By parity of reasoning, if you say the NPP constitution says automatic forfeiture,
yes,
and that is the same dispensation that operates in Article 97.1,
right,
why then do the standing orders of Parliament require this matter to be brought to the attention of the Speaker, for the Speaker to inform the House that the seats are indeed vacant?
All right. You see, very good one. So let's look at the effect of the Speaker's announcement. The Speaker's announcement is not the determinant of the fact that has come to exist. In fact, the fact must exist to be announced. And so what determines the existence of the state of affairs is the Constitution. And that's why I think I said somewhere that people have forgotten totally about the people, the members of Parliament who are duty-bound under the Constitution to vacate their seats. No one wants to listen to them. What if they have vacated the seat, actually? All this will not be of use. If indeed they have, and I don't think they have, since they have they've been allowed to put themselves in the conditions prescribed by the Constitution. I don't think they've gone back to Parliament again.
One has been going, at least we see her, Morrison.
No, in the chambers?
Yes, she joins the majority group, except that the last two occasions, they have not been able to enter. They have decided that to enter the chambers, there will be chaos because the NDC has been occupying their seats.
In fact,
so you see her with them, but they don't go in, so she too doesn't go in.
After the last sitting, she said publicly that she, even though she's going independent, she remains with the NPP and remains with the
just
majority.
three days ago. Yeah.
Well, so if she alone does that, that's fine. So which means that there is another route or route within the law to take her through. In that case, it is her that someone should take to the High Court to challenge her that she can't occupy the seat. Now, but back to the concerns of Ms. Azar. I'm saying that once the provision does not, what was the concern? What was his concern in this regard?
That in this circumstance,
Yes.
their announcement,
Yes.
which is futuristic,
Correct.
ought not be used against them.
You see, the announcement is futuristic or the conduct is futuristic. You see, this future present thing, look, once what the Constitution has prescribed is satisfied, you left the party. And the constitutional provision says that if you leave the party and you join another party, one, or you leave the party and you seek to remain in Parliament as an independent member, then you shall vacate the seat. Now, you've left the party. That, I have no doubt about it. This hula baloo about the...
You left the party,
yes,
but you are not seeking to remain in Parliament as the new party you want to join.
Now, if
you left the party to go as independent,
yes,
but you are not seeking to remain in Parliament as an independent.
No, that is not for the person leaving to tell us. Once you have left the party while in Parliament, it means you have left the side of the party
that brought you.
And so you remain in Parliament as an independent member.
Let's be careful before we stay here for too long.
Yes.
I agree with him that once you leave the party,
yes,
you must leave Parliament. Yes. My position is that having filed to go independent is not a sign that they have left the party.
George Bernard Shaw, you know him, is one of our colleagues, and he says, please, with all due respect, we need to know that an administrative tool to confirm a reality is not necessary.
Yes.
He says, you don't need an administrative tool to confirm a reality. The effect is what matters. By deciding to go independent, you have automatically, i.e. de facto, left the party. The constitutional provision is so clear. So I was coming to the point. Are you guys, he is saying this constitutional provision needs interpretation by the Supreme Court. The Supreme Court only interprets when there is what?
An interpretive issue.
Ambiguity. When
it's not clear.
Something is not clear. From where you sit, do you say this is clear enough?
Oh, for me, 97, the whole of 97, and particularly 97 G and H, are so clear that, you see, when you go to the Supreme Court's decision, the precedents for establishing where there is an interpretive issue, they have laid down the conditions so clearly. Though I believe that shouldn't be exhaustive, they have laid down the conditions so clearly that when two provisions of the Constitution are in conflict, or when a constitutional provision is unclear or is ambiguous, or when a constitutional provision is capable of more than one reasonable meaning, or when institutions of government are conflicting in their authority given by the Constitution, then an interpretive issue arises.
Are you saying that the fact that Afeyo Marking
Yes.
is going to court to say that the meaning the Speaker has put on this provision is not what it is. It's not enough to trigger the Supreme Court to interpret it.
Has the Speaker put a meaning to 97?
He has applied the Constitution.
Okay. And he says what? Now, let me make
He
this.
says what Opukweje is saying,
But let me-
that they may have left the party to go independent.
Yes.
Esiama may have left as independent to go join a party, but they do not seek to remain in parliament as the future job they want to do. They seek to remain in parliament as the parties that brought them there. Or as for Esiama as an independent, he seeks to remain in parliament as independent. So this is what the meaning should be.
Okay. Samson, what you have just said, is it an interpretation of Constitution or analysis of facts? Let no one make a mistake. And that's why 99 has given the High Court a certain jurisdiction. Look, what they are talking about is interpretation of the facts and whether it violates Article 97. That is not an interpretation of 97. Interpretation, as I've just said, look, there must be something unclear about the constitutional provision, not the facts. There must be something ambiguous. It must be capable of more than one reasonable meaning, or there must be something about the authority or power of two or more institutions of government.
But here
stated
you
by the
are,
Constitution.
one group says,
Yes.
for as long as you have left your party
Yes.
and you are joining another party
Yes.
to be elected to come back to parliament on that party's ticket, you have left. Another group says, yes, you are seeking to leave, you have not left. Okay?
Yes.
Or you may have left the party, but in parliament, you have not left the party. Is that not enough for the Supreme Court to interpret?
It is not.
It is not.
Because, you see, at best, what we are talking about is interpretation of the party's constitutions, not interpretation of this constitution. You need to interpret the party's constitution to come to the conclusion that the prescribed conditions in 97 has actually happened. And that is an interpretation of the party's constitution. And that's not exclusive
Before
to the
time runs out on us, and both of them have been referring to Article 99. 99 simply says that if there is a question about the vacancy of the seat of a member of parliament, anybody who wants to settle that question or that debate or that contest must come to the High Court. So don't confuse that. This Afeyo Marking suit says there's an interpretive issue. The Supreme Court says it's interpretation. It has nothing to do with going to the High Court. Right. So how do we get Parliament to sit? That's a question I asked him that have brought us here. How do we get Parliament to sit?
But before then, I actually wanted to talk about, I've seen that you sent me a ruling on the rate itself. And I've noticed that the Supreme Court has taken a decision as to their jurisdiction. So I wanted to, because you mentioned...
We're going there. How do you get Parliament to sit?
Well, that one is...
The first time,
Yes.
the House resumed.
Yes.
The House went back.
Yes.
That was on the 17th.
Yes.
Okay, no. When they went back, the majority at the time, having assumed the role of minority because of the Speaker's announcement, they didn't go into the House.
Okay.
The NDC was the majority.
Okay.
So, because MPP had lost 3 of their members, okay. NDC has lost only 1. And you know, in Parliament, they are all 137
one
each.
independent.
Right. So, in that circumstance, the Speaker said they had a quorum to do business, which is 92 members. But they didn't have the quorum to take a decision. The quorum to take a decision is half of all the members of Parliament present. Then the second time, when the majority now, we now say majority because the Supreme Court has suspended the decision of the Speaker. Yes. So they have come back to their original position. They requisition or compel the recall of Parliament. That was Thursday. Once again, they didn't enter the chamber because the NDC had gone to sit on the right-hand side of the Speaker. That's the majority side. The Speaker said, even though it is only the NDC that is in the House, they are unable to consider business because there is always something called the business paper, which must kickstart proceedings, and there was none. And the NPP was not also in the House. How do we get Parliament to resume?
Well, as for getting Parliament to resume, they can requisition Parliament again.
Oh.
Oh, yeah. The procedure is always there. But the point is whether they will be willing to go into the chamber and participate in parliamentary business.
They want the Speaker to tell the NDC group that on the basis of the Supreme Court's ruling suspending the decision of the vacant seats, they, the MPP, are the majority. So the NDC should not come sit on his right-hand side. They should sit at his left.
But that's onerous. If you require something onerous of someone and he's not doing it, he's not duty-bound. And he's clear about it, that he doesn't even have the power to do that. And that someone else has the power to do that.
The Clerk of Parliament.
So if you want him to do that and he's not doing that, then you have to trigger the process that will lead to the point where they will be told.
The duty of the clerk
yes.
is only to designate where they sit.
Yes.
The clerk has designated
yes.
that place, the right hand of the Speaker,
exactly.
as the majority.
Yes.
But the NDC goes in and they take all the inscriptions away.
Yes.
So they are saying, and many have also said, the way to resolve this is simple. The Speaker should simply say, NDC, I beg you, go to my left.
People are demanding too much of them. Look, but let me tell you this. Do you know that there's that division in Parliament is actually not constitutional? Or I should say, it is not a constitutional requirement.
Explain to us.
That when you enter Parliament, then majority should sit on the right side of the Speaker and minority should sit on the left side of the Speaker. And then they fail to create a place for people who don't belong to either. Now, and that is why this...
It is unconstitutional, but they say it is in their standing orders.
Well, if it's in their standing orders and it is offending a constitutional provision, and I'll tell you why. Because, you see, what happened to Asiama? Asiama, is it? You see, he was an independent candidate, and he was compelled to join one of the sides, right? That in itself, if you ask me, was a condition that requires to trigger off 97G or H. I don't know which one.
Samia Nkrumah had a similar situation.
Yes.
She was the only CPP member who got to Parliament, and she was told that you have to choose to do business with either the majority or the minority because there's no space for you.
You see, so that is the unconstitutional, but because the Constitution requires that if you are an independent member, you have to be able to remain in this chamber, in Parliament, as independent member.
We understand now their new standing orders have taken care of that.
Okay.
Now, let's now go to this. You had hinted that somebody was disobeying the Supreme Court's orders. Is anybody disobeying the Supreme Court's orders?
To the extent that the NDC goes to sit in the majority position, if the standing orders now make provision for where they should sit, then in my opinion they are.
If the standing orders or the Supreme Court's decision says these 4 seats that you say have been vacated are not presently, your vacation has been suspended.
Samson, the Supreme Court decision to suspend the Speaker's order is a restoration of the majority-minority position until the Supreme Court now looks at the substantive matter before.
That's right.
How is this manifest in Parliament? It's manifest in Parliament by having a majority leader and minority leader. And then where they sit. That is why I say that, in my opinion, it is a violation of the Supreme Court.
Does the manifestation of it include where they sit?
If
the Supreme Court's ruling has suspended the Speaker's announcement, he calls it announcement, he doesn't want to call it a ruling. Because the standing order says he should inform the House.
Yes.
He simply gave information to the House. If the Supreme Court's decision has suspended that for now, pending the final determination, do you need to sit at a particular place to obey the ruling?
Samson, I started out by saying that I don't think that where they sit is even regulated by any law. It's a convention. That was my understanding. You've pointed out to me that the current standing orders has it there. Without that, then you could sit anywhere. They could even intermingle, mix, and then it will still be majority, minority when it comes to voting and taking decisions. But if they are designated places, that is where I'm coming from. And the designation is supported by the standing orders based on who is majority, who is minority. That if you are doing something to dispute who is the majority, then you are disobeying the Supreme Court decision.
You who? The MPs?
The MPs. The MPs.
The MPs are not party to the suit. It is the Speaker who is party to the suit.
You and I know you don't have to be party to a suit to be.
I'm asking
to
you
be taken on
us.
To be taken on for doing something which would challenge the decision of the court. Let me just put it that way. Since you see, we are talking to the generality of the public. You don't have to be a party to a suit to do something to challenge the decision in a suit.
The orders were directed at who?
The orders were directed at the Speaker suspending his decision.
So who is supposed to act? Is it the Speaker or the MPs? If the orders were directed at the Speaker as the defendant, he's the first defendant.
Yes.
The Attorney General is second defendant. If the orders were directed at the Speaker, who is supposed to act on the orders?
The Speaker.
The Speaker?
Yes.
So why will any person other than the Speaker be guilty of disobeying the orders?
The Speaker is to act on it by suspending the orders that he has made, not implementing them, and then ensuring he's in charge of order and discipline in the House.
Right. Ensuring
that effect is given to it. Ensure that effect is given to the Supreme Court order. For instance, if any of the 4 MPs should walk into the chamber, it will be his responsibility to ensure that the marshals or nobody stops them. If the marshals go to stop them without his intervention, without his knowledge, it's outside his knowledge. But if they do it with his knowledge or even, let's say, his blessing, he hasn't stopped them.
So do you agree with Afenyomakin when he says the Speaker may actually be said to be disobeying the orders of the court? He says the Speaker cannot be said to be disobeying the orders of the court in the circumstances because the Speaker says,
I agree with him.
It is not his job
I've read
to determine where anybody sits.
I've read what Afenyomakin said, Honorable Afenyomakin, and I agree to a large extent with what he says. As I just said, Speaker has not stopped the 4 people from coming to Parliament. So he cannot be said to be in contempt of the order. He has done nothing to show an unwillingness to obey the order. He has actually even gone to court to attempt, or he went to court to attempt to get the court to vacate the orders, which is an acceptance, a recognition that those orders have been made. Otherwise, he could simply have said, I don't see those orders. So to that extent, you cannot say he's in contempt of the Supreme Court. Why I'm stretching this to, and I'm using the word stretch deliberately, is that if you see that some people who I am saying you should have control over by virtue of your being speaker, are doing what they are doing to disobey or to make it impossible for the Supreme Court's decision to be enforced, you are party to it.
The Supreme Court's decision, help me understand the point you just made and my audience.
Yes.
It is disobeyed when or if the 4 MPs attempt to enter the House and they are stopped, correct?
Oh, yes.
That decision is disobeyed when or if those MPs go into the House and they want to participate in activities of the House and they are stopped, correct?
Correct.
It is disobeyed when those MPs enter the House, they want to vote or they want to comment and they are stopped from doing so, correct?
Correct.
Is it disobeyed in any other way apart from this happening?
When you stop them from entering the chamber to sit where they are supposed to sit, the seat that has been designated for them to sit, you stop them from sitting there, in my opinion, you are disobeying.
When who stops them?
Oh, we just went over this. It's not the speaker stopping them. Let me just
You
get
said
that
the
out of
order
way.
is directed at the speaker.
Yes.
And it is the speaker who is supposed to act on it.
It's the speaker who is supposed to keep order in parliament.
Okay.
So he should keep order by ordering, please, this seat belongs to this person or that section.
Okay.
I've heard speakers say,
so now let's
it is not his
let's
duty.
look at it this way.
Yes.
Those people, those 4, we don't know that they have entered the House, and at least 3 of them belonging to the MPP. We don't know them to have entered the House seeking to sit at one side, and they have been prevented. Has the order been disobeyed?
No.
Yes.
If they have attempted to enter and they've been prevented from entering,
They belong to the majority group.
yes.
The majority has not gone in.
Yes.
Because they say they don't want to go in and provoke a fight. So the orders have not been disobeyed.
You have made it impossible for them to come in by occupying.
Who
this.
has done that?
NDC. I keep saying this.
Okay.
I'm not fixing this on the speaker. That
So
the speaker
the
has prevented
NDC have made it impossible for at least the 3 members who belong to the MPP to come into the House, correct?
Yes.
Okay.
2 members belong to the MPP, 1 independent.
Let's
For the
say
purpose of
3
clarity.
for MPP.
Okay.
Do you agree that, tell us first, how is this order of the Supreme Court said to have been disobeyed?
Oh,
What happens?
Samson, I think you have nailed it when you said it. You see, it is violated when Parliament refuses to allow the 4 members whose seats have been deemed to have been vacated to enter into Parliament and participate in parliamentary business. Because, listen to what the order says. It said, the Parliament of Ghana, not the Speaker, is hereby directed to recognize and allow the 4 affected members of Parliament herein named to duly represent their constituents and conduct the full scope of the duties of their office.
That's the second order.
Yes.
When the attempt to set it aside was rejected.
Yes.
But the first order simply said that the decision leading to the vacation of the seat is hereby suspended.
No. I'm talking about the Supreme Court's order.
Yes, I'm referring to that.
Yes.
You are referring to the order which was made after the Speaker tried to set aside
Yes.
the decision, the orders that were first made.
No. I think this is the order that was
Dated.
I think it's dated 18th October.
18th October.
Yes, 2024.
Okay, correct. Then that's the real one.
Yes.
Correct.
So this was the order that was given at the instance of Afenyo Markings.
All right.
Okay.
By
So-
ex parte application.
Yes, by the ex parte application. And it's directed at Parliament of Ghana. Okay? So, and what the order require of Parliament of Ghana is just to allow them to come into Parliament, represent their constituents, and participate in the full scope of parliamentary business. Now, this is what will be denied for the order to be violated. And as you said, no one if no one has prevented those members of parliament from entering into the chamber, and no one has prevented them from participating in the full scope of parliamentary business, then the order is not violated. It's as simple as that. Now, what is happening inside there are matters of procedure which are governed by their standing orders. So if someone is in breach of the standing order, they know what to do.
The order is that.
Yes.
The Parliament of Ghana is hereby directed to recognize and allow the 4 affected members of Parliament
Yes.
to duly represent their constituents and conduct the full scope of the duties of their offices as members of Parliament, pending the determination of the suits.
To recognize and allow.
Yes. The MPs, they are members of Parliament. The NDC MPs, they are members of Parliament.
Yes.
Correct?
Yes.
Are they not making it, as he said, impossible for this order to be carried out?
No. Question is, have they recognized their membership of Parliament? If yes, have they allowed them to participate fully in the business of Parliament? If the answer is yes, they are not in violation of this order.
We'll take a quick break. We'll be right back. Welcome back. I have Osman Alasan and Opokwe J, and unfortunately our time is up. So, educators, there have been suggestions of citing the Speaker for contempt or doing otherwise, which is possible.
Well, I mean, if they can cite him for contempt, but whether he will be guilty of contempt is another thing. Because contempt is when you willfully disobey an order of court, or you conduct yourself in a manner that brings administration of justice into disrepute. So if none of these happened, and you see, when you say willful, it means he has the power to do something that he hasn't done. But if the man is already telling us that, look, what you are expecting me to do is neither expressly stated in the order, nor do I have power to do it.
There are also those who have referred to Article 2 as the Chief Justice has done herself when she was giving the second ruling, that disobedience of the orders of the Supreme Court amount to high crime, and you could go to jail for 10 years, and after 10 years, after you have served your jail sentence, for another 10 years, you will not be able to hold a public office.
You see?
Samson.
Yes, quickly, then we'll go to Pope.
Okay, so you see, I think I have made my position on this one very clear. You see, the orders that are supposed to be disobeyed for someone to be guilty of high crime are the ones that have been made to enforce a declaration, which is made saying that someone's conduct is in violation of the Constitution.
That's at the end of the trial?
At the end of the trial.
Okay. So that doesn't come in?
That doesn't come
in.
Yes.
Samson, I am looking more in this case at the possibility of a high crime than contempt of the Supreme Court. But I do not see the Speaker's actions so far as amounting to anything.
Disobedience of the Supreme Court's orders?
Yes. As I have said, I don't think he has done that. If there's any disobedience, it's not from the Speaker.
But he's saying even if there's a disobedience,
and I understand,
high crime does not come in, because high crime comes in when the orders are orders as a result of the end of the case. This is only interim order, it's not the end of the case.
Well, I'm not sure that interim orders cannot trigger a high crime. An order from the Supreme Court is an order from the Supreme Court. I'll have to probably go and look at it again, and then so that I can agree or disagree. But I'll be honest, I'm not sure whether interlocutory orders are exempted from triggering a high crime.
We are sticking to law. Should the Speaker tell the NDC guys, move away and let the MPP guys come as majority?
I think the Speaker should. But even if he doesn't, I don't see why the MPP cannot still enter the chamber, whether they are sitting to the left or right of the Speaker, and conduct business.
They should enter.
I don't see.
And sit at the minority side.
Minority side, majority side. At the end of the day, will you be addressed as majority or minority?
Okay. Should the Speaker do that?
No, they should go into the chambers with their 138 members and make the point that a standing order is being breached for Speaker to rule.
137. We understand that they simply cannot get the 137 to come to the House at this time of the day. Well, and that's the problem, because once they don't have half of the members, they can't take a decision. And this has been the law. It's your legal light. It is your health law. I'm Samson Ladi Anyani, and I was joined by my good friends, Osman Al Hassan and Opoku Ejei.